Very key. Okay, I think we're good to go here. So I'll just start again. Attorney Susan Lund is the Employability Priority Coordinator at the Legal Action of Wisconsin and the Supervising Attorney at the Center for Driver's License Recovery and Employability. She specializes in removing legal barriers to family-sustaining employment for low-income clients in Milwaukee. She's the chair of the Public Interest Law Section of the State Bar, a member of the Milwaukee Bar Association Courts Committee, and a monitor and peer assistant with the Wisconsin Lawyers Assistance Program. I have long heard about all the great work that Susan has been doing, and I've greatly benefited from her expertise in this process. And again, we have attorney Kori Ashley, who was born and raised in Milwaukee, Wisconsin. She completed her undergraduate education at DePaul University, where she received a bachelor's degree in political science. She received her Juris Doctorate from the University of Wisconsin Law School in 2012. After graduating, Kori practiced criminal defense law in various counties in Wisconsin. She's currently a public interest attorney at Legal Action of Wisconsin, and she works in the Milwaukee office in the Road to Opportunity Project, assisting clients with removing barriers to employment, housing, and educational training opportunities. Kori is a member of the Wisconsin Association of African American Lawyers, Milwaukee Bar Association, and sits on the Eastern District of the Wisconsin Bar Association's Board of Directors. In October 2017, Kori participated in the Shriver Center Racial Justice Training Institute, a national leadership program grounded in the commitment to race equity as an integral and essential part of anti-poverty advocacy. Kori is also co-chair of the Young Lawyers Division as a free clinic, Project Street Youth. And in 2018, Kori was named Attorney of the Year by the Wisconsin Association of African American Lawyers, or WAL. In June of 2019, she was elected as chairwoman of the State Bar Board of Governors, and Kori was appointed to the Branch 19 of Milwaukee County Circuit Court by Governor Tony Evers in June of 2020. She lives in Milwaukee with her husband and her one-year-old son. So we're really lucky to have attorney Kori Ashley back and attorney Susan Lund with us today to talk a little bit about post-judgment matters in municipal court. Before I turn it over to Susan, I also wanted to mention if you have any questions, we'll be taking questions as we go. So if you have any questions, please put them either in the Q&A or the chat function, and I will be keeping track of that and facilitating questions as we go through this presentation. All right, Susan, I'll turn it over to you.
Wonderful. Thank you so much, Emma, and thanks to everyone for coming. As Emma mentioned, you could just go to the next slide. If you're tuning in for the first time, there was some great content previously, which is available by video. So the municipal court overview, constitutional rights, protest citations, pretrial matters, and trial practice were covered previously. Today, we're just going to be talking about post-judgment issues. So that's going to involve motions to reopen, appeals, preventing or resolving sanctions for non-payment, and clearing or correcting court records. In the timeline of the municipal case that we see here, obviously we're at the end talking about the appeal, the due date, poverty hearings, and sanctions for non-payment. And we just wanted to start by talking about reopening municipal court judgments. Hopefully this doesn't come up, but we think that it's very possible that it will. We know that in Milwaukee, City Attorney Spencer indicated publicly that he was going to be dismissing a good deal of the protest citations, and that's really excellent news. But when that announcement was made, it was not very specific. And we do think it's possible that a fair amount of people heard that, assumed that their issue was resolved, and put it out of their mind. And then in August or September, they might get a notice of default judgment in the mail telling them that they missed a court date and that they were therefore found guilty and owe some money as a result. If that happens, all is not lost. The estimate is that about 70% of cases in municipal court end in default judgment. And so motions to reopen are a very common occurrence there. And so, you can and should use a motion to reopen if you have a client who wants to dispute a ticket anyways. And so I would encourage folks to take these types of cases, even if someone's been found guilty by default early in the process. And this graphic here is just supposed to demonstrate that when you do a motion to reopen, the judgment is vacated and you go back to the beginning of the case. And that would also resolve any sanctions for non-payment which had been imposed as well, because if there's no longer a judgment, then there can no longer be a forfeiture. And if there's no longer a forfeiture, there can no longer be sanctions for non-payment. So that's just what that's supposed to demonstrate there. So the authority for motions to reopen in municipal court is Wisconsin Statute 800-115. There's three main ways to go about doing a motion to reopen. The first one is that within 6 months of the judgment, you can assert mistake, inadvertence, surprise, or excusable neglect. And again, that's done within 6 months of the judgment, but not the alleged violation. So that gives you a fair amount of time. So for example, if your client heard the city attorney's announcement or saw a news story and assumed that their ticket had been dismissed based on that, and then later found out that it wasn't, that might work for an argument of mistake. The really common kind of slam dunk arguments that we see are someone who is hospitalized or incarcerated and therefore couldn't make it to the hearing. And, you know, another fact pattern that might work for this would be COVID-19 related issues. If somebody was sick or under quarantine or their family member was sick, something along those lines might work as the fact pattern goes. But, you know, if you're outside of the 6 months or you can't make the facts fit into one of those boxes, at any time, any party can move to reopen a case in the interest of justice or for some other reasons, such as fraud, if it's no longer equitable to have prospective application of the judgment. And so those are less time limited. I rely on interest of justice a lot. I get a lot of cases well past 6 months. And so that's something that is often very successful. And it's something to consider, even if you're going for one of the first options. Like if you're arguing mistake, you can also just throw some interest of justice in there as well. It doesn't hurt. And then the last thing to consider is that you can stipulate with the prosecutor to reopen the case. And if the judge signs off on that, then you're in good shape there. So especially right now, because in Milwaukee Municipal Court, they're no longer taking walk-in, which is normally how you would get a motion to reopen heard. It doesn't hurt to reach out to the prosecutor and see if they would stipulate to reopen. This is gonna be likely easier if you're trying to accomplish something like getting a deferred prosecution agreement or a reduction in charge or something like that. I think a prosecutor might be less inclined to stipulate to reopen if they know that you want to take it to trial, but it's certainly an option that you've got. And I just want to point out that it's pretty common for courts to have a standard motion to reopen form available on their website, or if you call and ask for it. And I think Milwaukee's is linked in the materials, so you can draft up your own or you can just rely on that court form. A big part of the motion to reopen process is that judges normally impose reopening costs or fees. This is a big barrier for my clients who are all low income. Your clients may have higher incomes, and if that's the case, absent some really extenuating circumstances, your client's likely going to have to just pay the court costs. And in Milwaukee Municipal Court, the standard cost of a motion to reopen is $20 per case. I have seen motion costs assessed as high as $50 per case in municipal courts. And technically, a court could assess up to $300 in motion costs. One thing to note is that this statute was recently updated. And as part of the updates, the poverty protections were made more clear. So that's something to keep in mind. And it's something to keep in mind that the judge may not be as familiar with yet. But the statutes do now say that the judge must consider the defendant's ability to pay using the poverty criteria laid out in 814-29. They also say that the defendant can't be required to prepay motion costs in order to have the request heard. And then it also says that the motion costs must be assessed based on the associated expense. So those are some things to keep in mind when you're arguing about motion costs. And if you're arguing for motion fee waiver based on poverty, you're going to want to review the exact language of the statute, 814-29. But one of the easier and most common ways is if your client receives mean tested public assistance. So that's like food share or Medicaid. And so, you know, the argument would be if the individual receives food stamps, you make a request for a finding of poverty. And if the court makes the finding of poverty, you know, as they would be required to do for someone who receives means tested public assistance, they'd be required to waive fees and costs. So I think that it violates the law for the court to assess motion fees to folks who demonstrate that they qualify for something like food share. Now, whether that's going to be successful, you know, is another story. Many judges, including judges in Milwaukee Municipal Court, will deny your motion to reopen if you don't pay those motion fees, even if you establish that your client is statutorily indigent. And that's just a fight you're going to decide if you want to have or not. I have appealed decisions on motions to reopen that were denied because my client wasn't able to pay motion fees, and you could do the same. It is an appealable decision, and I will turn it over to Kori to talk more about the appeals process.
Thanks, Susan. That is a nice segue. I will point out first, just to follow up on what Susan was saying, is that if you do file a motion to reopen, that proceeding should be recorded under a new statute in Chapter 900 or Chapter 800, excuse me. So you can have a better record on appeal. So that's something practically in the city of Milwaukee, if you are going in to request that hearing, you should, it's a new thing, new as in the past several months. So you might want to raise that just to ensure that that proceeding is being recorded for appeal purposes. But otherwise, appeals to circuit court from a municipal court judgment, the authority for it is found in Chapter 800, WSStat Chapter 100, WSStat 800-14. You should know that default judgments, which happen very commonly, as Susan described, are not subject to appeal. But again, you want to look to see if you can reopen those cases in another manner. But you are able to have judgments, so decisions after a trial, decisions on motions to reopen, other judgments in municipal court, decisions on indigency, poverty motions, appeal to circuit court. And there is a procedure that you have to file, and it does trigger time constraints. So the first thing that you want to do after a judgment or after an adverse ruling for a client is, I always say, move quickly to make sure that you're aware of these time constraints, but you want to give the municipal court and the other party, the city, written notice of the appeal by filing the form. City of Milwaukee does have a form on their website, as many municipalities do. You want to file that form and pay the required fees within 20 days of the judgment or the adverse decision. In terms of fees, if you are requesting an on-the-record appeal, which I will talk about, that's $99 plus the cost of bond. A de novo, a brand new hearing, bench trial before the circuit court is $104 in the city of Milwaukee, plus the cost of bond. And there is, if you are seeking a jury trial, a 6-person jury trial, there's a $36 fee that you must pay within, I think it's 10 days, right? Within 10 days of your appeal in order to prevent waiver of that right to the trial. You can go to the next slide. Thanks, Emma. Or you can go back, I'm sorry. So an on-the-record appeal essentially just means that the transcript of the proceeding is going to be forwarded to the circuit court, and the circuit court judge is going to review under a clearly erroneous standard to determine if the municipal court's judgment is going to be affirmed. The circuit court may require briefs, but it does not have to under Chapter 800-14. Most will, so I would be prepared to write some form of trial brief or outlining the issues for the circuit court, but just know that it's not required and they do not have to. At that point, the circuit court will review on the record and make a decision, and they are going to give due consideration to the municipal court's opportunity to assess the credibility of witnesses that they've done at a trial or at the during the proceeding. Let's see. Within 30 days of your appeal, that transcript is going to be forwarded to municipal court or forwarded to circuit court. And just by practice, I always try to call kind of midway through. I've never had an issue get a transcript being transferred over to circuit court. Sometimes I don't get it. And so that's why practically I'll call and try to figure out where it is in the process. As far as the cost for transcripts, if your client is unable to pay and there's inability to pay issues regarding that transcript fee, they can file a fee waiver regarding both the fees for the transcript as well as the fees for the on-the-record appeal related to the actions and indicate that they have poverty issues. Your other option, other than an appeal on the record, is a new bench trial. That is, of course, a de novo, you start from the beginning before the circuit court. In those scenarios, the standard of review, I think if we're looking at a curfew ticket case, I think there might be some tension as far as if you're going to get a standard of review that is the preponderance, which is the typical forfeiture burden in circuit court, as opposed to the clear and convincing standard that you get in municipal court. There is some case law on whether or not if the curfew citation is deemed to be under the general municipality's regulatory powers, you're probably going to be subject to that lower burden of proof. If it's deemed to be an act that could also be made criminal, I think you're going to get that higher burden of proof that you get in municipal court. I would be prepared to obviously argue, you want to argue for that higher burden, but there might be some tension there as far as that standard of review if you go for a circuit court bench trial. So let's see, we've talked about an appeal on the record. We've talked about a new bench trial. Your other option is to pay the jury fee, which I know is could be a very attractive option for individuals who want to challenge kind of the fundamental issues underlying these arrests in circuit court. And so be prepared to get that fee submitted timely so you're not waiving that right. Okay, just looking to see if there's a question. Okay, let's see. Anything else I want to cover regarding appeals? At the conclusion of your appeal, if you are successful, I would just practically point out that whatever order is going to be sent from the circuit court to back to municipal court, you're probably going to be drafting it. And I would just make sure that that language is very clear what the circuit court is remanding the municipal court to do. Just so it's, there has been some, I don't want to say issues, but that has been a problem for me before. So if you are in charge of drafting that order, just make sure the language is very clear so you can get prompt action from the municipal court in terms of whether or not, if in fact you were successful on appeal. I think that's all on appeals that I have. Susan?
Kori, I think we just have a question about the reporter. So if there is no reporter, who do we contact to get a copy of that recording? And then who do you get, and then do you have to get a private reporter to transcribe it?
So you can contact the clerk for the City of Milwaukee Municipal Court to get a copy of the digital recording. And it is then transcribed by the city. I'm not sure if it's the city that actually does it, but that's how I've gotten it two ways. I've gotten it from the city, and I've also gotten discs with the digital recording that I've then had to have transcribed. So I've had it done in two separate ways.
And I would just add, there have always been issues with filing municipal appeals. Now there are new ones kind of related to e-filing in the process. And so it's a pretty short deadline to file that appeal. I would encourage you to file it as soon as possible. The last time I helped a colleague file a municipal appeal, it had to be refiled 4 times. And I'm hoping that those issues have been resolved. We've been told that they have, but it's worth just trying to file pretty early, just to make sure it doesn't become a problem with the timeline. Kori, was that it for appeals?
Yes.
All right, we can go to the next slide. So municipal courts have the they have the authority to order financial penalties, so forfeitures. But then if the individual doesn't pay by the due date, they have additional authority to order sanctions for non-payment to try to get the individual to pay. Collection options as well that the courts will use. My favorite is TRIP, the Tax Refund Intercept Program. It's a pretty passive collection mechanism that the courts use, and the fees are really low, usually about $5 per debt. And this is not to say that it's not a huge blow to folks who are expecting a state tax refund and then just don't get it and have all their money snatched by the municipal court, but it is, in my mind, preferable to some of the other options, which are much more costly and invasive. So an example of another option would be the state debt collection agency, which more and more municipal courts are using every day. So when a debt is referred to the Department of Revenue State Debt Collection Agency, this can involve some really active collection means such as garnishment and bank levies. And the fees are really high. So there's a minimum of a $35 fee assessed for every referred debt, which means every separate ticket. Another incredibly common sanction for non-payment is the driver's license suspension. So a court can suspend a driver's license for up to 1 year to try to coerce payment if it's a traffic ticket or a juvenile ticket. And then finally, the other sanction for non-payment I want to touch on today is the writ of commitment. This is commonly referred to as a warrant. The court may order that the defendant be imprisoned until the debt is served at a rate of no less than $50 per day. So any traffic or non-traffic ticket can result in a warrant for non-payment, but juvenile tickets should not result in warrants for non-payment, although they can result in failure to appear warrants. Next slide. Thank you. So when we're talking about driver's license suspension caused by non-payment or poverty, this is a massive problem in Wisconsin. Shockingly, most driver's license suspensions in Wisconsin are caused by non-payment of traffic tickets. So we're talking 54% for failure to pay, a couple more percentages for failure to pay juvenile tickets, nearly 200,000 driver's license suspension for non-payment of tickets last year. So, you know, this is not a small problem. And this debt collection mechanism has a fundamental problem with systemic inequities, right? So for example, Black men in Wisconsin are nearly 5 times more likely to have a suspended driver's license than white men. And it's frankly just a counterproductive debt collection tool. We all know that a driver's license is a huge asset for employment purposes. And when you take away that driver's license, that person may lose their job, or they certainly will lose out on job opportunities. And that makes them less likely to pay their debt. So yeah, it's counterproductive and problematic. Yeah, you can go ahead. The same is true for warrants for non-payment. They are unjust in the vast majority of cases. And again, it's been an ongoing problem in Wisconsin. In Milwaukee County, nearly 10,000 people served time on warrants for non-payment from 2008 till 2013. And there are massive systemic inequities. So in Milwaukee County, which I think is about 25% Black residents, 78% of the people who served time on warrants for non-payment were Black. So that's a huge problem. And so many more people who didn't serve time suffered with increased police scrutiny or police stops, or were stopped and had to cough up hundreds of dollars to avoid incarceration and all of the things that go along with that, which is, you know, problems for their family, problems for employment. And so this is a really harmful debt collection mechanism. And again, it's really harmful to long-term employment prospects because incarceration record is, again, one of the biggest barriers to employment. So this is all to say that when you're representing a client, don't quit at the judgment. If they're found guilty and found to owe some money, make sure they have a plan to avoid sanctions for non-payment. Especially if they plan to continue going to protest, the last thing they need is to have a warrant hanging out there giving police another reason to have contact with them. So if they owe money and they can afford to pay it, they should pay it. If they can't afford to pay it, they might be able to reach out to the Milwaukee Freedom Fund and see if they might be able to help with the debt. But either way, let them know why it matters, and don't let it just fall off their radar. If they can't afford to pay in full, they have good options. So they can set up a payment plan or request community service. Oh, you can go on to the next slide. Yeah, so they can request a payment plan or community service to prevent sanctions for non-payment, so it doesn't become a problem for them in the future. And there are poverty protections. The courts do have obligations to grant them something reasonable to avoid sanctions for non-payment that are caused by poverty. So generally the statute you're going to use in these circumstances is Wisconsin statute 800-09-1G, which says in part, if the defendant is present and the court using the criteria in 814-29-1D determines that they are unable to pay the judgment due to poverty, the court shall provide the defendant with an opportunity to pay the judgment in installments, taking into account the defendant's income, or to perform community service in lieu of payment of the judgment. Another option that you can request is you can ask for a modification of the judgment to a lesser amount or a permanent stay of the judgment, which just means they would zero out the balance. The statutory language here is permissive. It says the court may at any time authorize payment of the monetary judgment by installment payments, or may modify, suspend, or permanently stay the judgment, or order that it be satisfied by community service. So modifications and stays are really powerful tools that the judge has, but they're usually reserved for more extreme situations, such as clients who might be homeless or those who are struggling with addiction or mental health issues. But again, you can get creative with this because the Milwaukee Municipal Court judges will also sometimes stay or reduce debt if your client enrolls in college or graduates or secures a job. And so that's something to keep in mind. But I do just want to make clear, because it's an ongoing problem in municipal courts, that the judge has very limited discretion when it comes to making findings of poverty. So if your client meets the statutory criteria, like means-tested public assistance or representation by legal action of Wisconsin or the public defender, the judge has to make a finding of poverty. So if your client wants to avoid driver's license suspension or warrant, they have options. They shouldn't just ignore that money judgment. So let's hope this doesn't happen, but it may. Your client may contact you after they've already had sanctions for non-payment. Oh no, I'm sorry. Could you go back one? Yeah. So they may contact you after they've already had sanctions for non-payment imposed. I'm sorry, could you go back one more? A little lost here. There we go. And I just wanted to point out that when you're trying to attack sanctions for non-payment, you don't have to reopen the case. You may reopen the case, but you can just attack those sanctions for non-payment without fully reopening the case. So you don't want, if you're just trying to resolve sanctions for non-payment caused by poverty and not reopening the case, just keep that in mind. You could go ahead again, I'm sorry. So again, if the sanctions have already been imposed, that's not the end of the world. There are rights and poverty protections that you can invoke. So if you want to lift a driver's license suspension caused by non-payment, after it's been imposed. You know, our favorite statute is Wisconsin Statute 800-095 1A5. And that says, during the privilege of operating suspension under this paragraph, the defendant may request that the court reconsider the order of suspension based on an inability to pay the judgment because of poverty, as that term is used in 814-29-1D. The court shall consider the defendant's request, and if the court determines that the inability to pay the judgment is because of poverty, the court shall withdraw the suspension and grant the defendant further time to pay, or withdraw the suspension and order one or more of the sanctions set forth in this subsection, including community service. And then if you wanted an installment plan, you could use a statute that directly deals with the installment plan, 800-093B, which gives one clear shot at an affordable installment plan for somebody who meets the poverty criteria in 814-29. And then, of course, you can always ask for a modification or a stay if you'd like to. And then finally, there would be different statutory authority if you're trying to lift a warrant for non-payment that has already been imposed. So the poverty protections here are really strong, and rightfully so, because of the liberty interest at stake. So Wisconsin Statute 800-095 1B2A says, no defendant may be imprisoned for non-payment unless the court makes one of the following findings, and those can include either at sentencing or thereafter that the defendant has the ability to pay the judgment within a reasonable time. If the defendant meets the criteria in 814-29-1D, the defendant shall be presumed unable to pay, and the court shall either suspend or extend payment of the judgment or order community service. So, you know, this is a powerful tool. If your client is meeting the poverty criteria in 814-29, you know, you should not be met with resistance to lifting those sanctions for non-payment and giving your client an affordable option. And again, you know, here you could try to use that catch-all that they may modify, suspend, or permanently stay the judgment. But I just want you all to know that if your client meets this poverty criteria, the judge has to hear their request to resolve these sanctions for non-payment and give them reasonable, affordable options. And I just also want to mention that there are template motions in the materials if you need them.
Okay. So the last topic that we want to cover today is in kind of that same vein of making sure that your client is thinking about things, even if, for example, a judgment is entered against them, not letting things sit. We want to make sure that there's comprehensive representation. So if you are successful in obtaining a dismissal of the municipal court citation, whether it's a curfew citation, a disorderly conduct, maybe a resisting, my understanding is those are the citations, some of the citations, a sampling that folks are seeing, then you want to make sure that the complete event is removed from that client's life. And that means making sure that the record of that arrest is not lingering on their background report. One of the things to consider when you are first engaged with a client is asking them, you know, were you arrested? Were you detained? Were you fingerprinted? Because if a client has been fingerprinted, what's happening is a notation is being made of that arrest on their criminal background report. So before I get into that, I just want to do a general overview of arrest records. We all know, I don't have to talk about how stigmatizing that they are. In this day and age, they are easily accessible online. They are cheap. You don't need the subject's permission to get access to these records. They're out there and they're everywhere. And decision makers are using them to determine whether or not your clients are worthy for a lot of things, right? I hate that term, they're worthy, but that's what they're using them for. Are they worthy of employment? Should they get this house? Should they get this loan? And so we want to make sure that if we have the ability to remove the taint of an arrest from a client's background report, that we're getting that done. So under Wisconsin Statute 165.84, this is the authority to have an arrest that did not result in a charge or was either cleared through the court proceedings, removed from a background report. But of course, it's upon request. This is not done automatically. The burden is put on the subject to submit this request to the Department of Justice. These criminal history reports, they're called Crime Information Bureau reports. We call them CIBs at Legal Action. They're managed by the DOJ. They cost $7 to get. I think it's good practice to just, run your client's record. You really only need their first name, their date of birth. I think now the department is requiring a gender and a race. That seems to change frequently as well. But you run their report, and you can do so at recordcheck.doj.org, and there should be a link in the materials that you have to determine if their detention or if their citation in this case is reflected on their background report. And if it is, and at the conclusion of your representation, you've gotten a dismissal, and that was the only charge in that arrest cycle, then you're going to be able to get that removed from the report. And so what the rule essentially means, and I want to give a couple of examples so it's clear, is that an individual is arrested, say they're arrested for disorderly conduct at a protest event. And that case is either dismissed because the city attorney has decided not to prosecute that case, or you are successful after a trial. And that's all that your client has been arrested for, but they were fingerprinted. Then there's going to be a notation on their background report, and that arrest, that cycle is what it's called, is going to be eligible to come off. However, if your client was, say, picked up for disorderly conduct and criminal damage to property, and say you negotiated down the criminal damage to property and they end up with a disorderly conduct conviction, that entire cycle is going to have to stay on the report because one of those charges stemming from the arrest resulted in conviction. So when you're analyzing these reports and you're trying to determine, what can I get off, just remember that each charge within a cycle, each charge within an arrest event has to have been cleared through court proceedings or not resulted in a charge in order to be eligible to come off of the background report. You can go to the next slide. So what you're seeing here is that request. It's the actual fingerprint removal form. I would probably just keep these handy as you're representing clients, because my understanding is that many of these folks were in fact arrested, and this is probably living on their background reports. So when you're submitting a request, what you want to do is if you're submitting it on behalf of the person, your name is going to go first. So the person submitting the request, you're going to submit that request. You can, of course, also assist the person with filling out this form and just making sure they do it correctly and put in your client's name here for the form to be returned to your client. And then in that next section, it's the subject of the record. You want to enter your client's name and information as it appears on that CIB, on that background report you ordered. If the report, say your client says, oh, they spelled my name wrong, you still want to spell it wrong because of the way that it's tracked. It's in the system wrong, so you want to send in the request the way it's reflected on the report. You're then going to list the date of the arrest, and you're going to get this information right from the background report from the CIB. The date of the arrest, the arresting agency. The arresting agency case code is very often not listed on the CIB. So you provide as much information that the report provides. If you don't get an arresting agency code, that's fine, just leave it blank. The date of conviction or adjudication, or in this case, the date that it was, dismissed, disposition date, the name of the court, and then whatever that charge or disposition was. You want to provide documentation that those charges were dismissed. So you might have your dismissal slip from municipal court that you can include. Sometimes the city of Milwaukee doesn't report the disposition of cases to the Crime Information Bureau, so you probably will have to submit some documentation. Other municipalities operate differently. So you might pull a CIB and it might actually have been updated and reflect that the case was in fact dismissed. If the CIB reflects a dismissal status, you don't have to send anything to prove that the case was in fact dismissed. You do have to send in the request to get it off the report, which sounds crazy, but it's still true. You also want to include a copy of that CIB that you pulled with the request. So you're going to have in, you know, a form cover letter, your fingerprint removal request, where you'll have fingerprints from your client's index fingers, and then a copy of that Crime Information Bureau report going to the Department of Justice requesting or demanding that that fingerprint is returned. And then, of course, the practical effect of that request is that they're going to remove that cycle from the report. You can go to the next page. Law has been active with trying to make sure that this law is as good as possible for individuals dealing with these issues. Some relevant cases, Teague v. Schimmel. This case was litigated over a period of 7 years. It was happening before I came to legal action, but it established that individuals have a right to challenge, a statutory right to challenge any incorrect record under 1970. And so that case involved an individual who, when they pulled his background report, the report for another person who had an extensive criminal history was returned for him. This, you know, our client did not in fact have this criminal record, and believe it or not, that was not immediately rectified by the DOJ. So there was litigation to ensure that if you're dealing with an incorrect record, you do have a right to challenge that under 1970. So that's a horribly brief description of Teague v. Schimmel. We also recently litigated Hall v. DOJ, and this case was about whether or not the Department of Justice can cycle unrelated charges together to prevent expungement. And the best way to explain that is, you know, our client had one cycle that had arrests, 2 different arrests that were separated by years. They were from factually different circumstances, and one resulted in a conviction, one of these arrests, and one of them did not. And of course, the one that did not was a very aggravating criminal charge. And it was a civil conviction that did result in a conviction, but of course had nothing to do factually with that criminal arrest. DOJ denied the request to take that off, essentially saying, I should know the argument, this was my case, but essentially they said, every charge has to be released in order for us to take this off the report. They're both on here. One of them resulted in a conviction. We're not taking it off. The trial court and the Court of Appeals agreed these cases don't have anything to do with each other. He was subsequently released without charge, as the statute says. You know, the way you cycled this is a policy decision. You can't do that. You can't cycle unrelated charges together to allow someone not to have the benefit of their statutory right under 165.84. So if you do happen to get when you're pulling CIBs, I say this to say, if you get a case where you have a client who says, hey, this isn't my record, right? We've seen this with twins. We've seen this with people who have close social security numbers. This isn't my record. You might want to reach out to us. So there's a lot of work already done on those issues. Or if you have a client who has a cycle that is incredibly long and they appear to be arrests that have nothing to do with each other, it's worth reaching out just to make sure that there's not a brief to be filed. Of course, if the DOJ denies your fingerprint removal request, it is a final agency decision, and you have 30 days to appeal and file a 227 action in circuit court. That timeline is firm, so you want to make sure that you either consult with folks who handle these cases more frequently, which we do at law, or otherwise to make sure that that's not something that you want to avail yourselves to, but you do have appeal rights if they deny your fingerprint removal request. And that's one of the reasons why we encourage you to send that CIB in so it can be a part of the record after, if you do file an appeal.
Hey, Kori, I just wanted to jump in to say that a lot of the reason these things get cycled together is because people have these post-judgment warrants, right? So they get arrested for, you know, say, battery, right? A criminal battery, but they also have an outstanding unpaid ticket or an outstanding failure to appear on a municipal ticket. And that's how those things get cycled together. And that's just another great reason that you don't want these post-judgment sanctions hanging around, because the repercussions in that case are, incredibly hard to fix. But hopefully there's some good precedent for folks in the future. But just another good reason not to let warrants for non-payment get issued, or municipal warrants have hanging out there.
And let me do a better job explaining what a cycle is. Thank you for your question, Allison. I'm now looking at the chat box. I wasn't the other day. So on a CIB report, the way that the DOJ organizes, so each time a person has contact with law enforcement, each time they are fingerprinted, what that does is generate what's called a cycle on that CIB report. So when I say a cycle, what I really mean is some sort of arrest event. And that's typically triggered by someone being arrested and then fingerprinted. And then what happens on a CIB report is they'll say cycle 1, and then right below that, arrest date, say it's for a curfew violation, and it'll list, the arresting agency, the date of the arrest, if it was actually charged. And the CIB is actually meant to chronicle individual's criminal history. So theoretically, it should list the arrest, the charge, and the court information and the disposition. That's not always the case. CIBs are frequently incomplete. Sometimes you will just have the arrest and the charge, which can be problematic if, of course, an arrest did not result in a conviction and it shouldn't be on the report anyway. But that's what a cycle is. A cycle is the beginning of an arrest event. It's how the DOJ organizes contact with law enforcement on criminal history reports.
And I would say a good clue as to what's going to be involved in the cycle is what is listed on the fingerprint card if you do get your hands on it. So the reasons that they list, like 1, 2, 3, 4, 5 on the fingerprint card, if it gets listed on that, oftentimes it's going to be included in that cycle, I think.
I don't have anything else on CIB reports. I could go on all sorts of rants, and I'm not going to do that in an hour brown bag lunch. But if there are any questions, additional questions, I'm happy to answer them.
And I'll just make another plug for Kori's very good advice that if you're ever meeting this individual in person, that is a good time to snag their fingerprint, because if you're having them sign off on some form or something, get their fingerprint. I mean, we use some special fingerprinting pad, but frankly, I don't see how it's different than if you just had a regular ink pad, and you just have the person roll their finger there and roll it on the page, and then you've got it in case you've got a dismissal later. It is not infrequent that we lose track of our clients during that time period, and it's just good to get that documentation up front, because you can't get a removal unless you've got those fingerprints.
And I should say now your client has to sign the form. That did not used to be the case. I just got a form returned to me. So you'll see the 2 index finger blocks right above that is a space for the signature. Do have them sign that. That is now being required.
I have a question about community service. So in my experience, some courts will say, we don't typically do community service, or, I guess, what is your advice, or what is the process to go through if that's not the norm, but you're trying to get your client community service, especially if they are a minor?
Oh, that's disappointing, right? So what I always try to convince them of is this is a very low effort endeavor on your part, because what we do is we make sure the individual goes to a nonprofit, completes the hours, we get a letter of completion, and we submit it to the court, right? So that's it's almost as easy as had they paid it. And it's certainly really appropriate to order community service in a lot of circumstances, but we do have judges who just flat out refuse and never will. But what we argue in those cases then is that it looks like you're going to permanently stay this debt. I mean, my client can't afford a payment arrangement. You're threatening a warrant or suspension. It's clear there is no reasonable payment plan for them, and you don't want to do community service. That's, I guess your prerogative, but we need something here. You can't be giving no feasible options to a person who can't afford to pay. And so we do have courts that will stay debt but won't do community service. So that's what we argue, or modify it to something that they could pay. Or if they're really not willing to do that, okay, let's revisit this in 3 months and see where we're at. So they'll push it out some, but if you've got a judge that says, I'm not ordering community service, you have to pay $50 a month, you should appeal that decision. And I have done that. And I think, I don't think we've lost on any municipal appeals from poverty hearings, because I think generally speaking, the circuit court judges are pretty outraged to see what's going on in the municipal courts, and they find it unacceptable and not meeting statutory or constitutional standards. So if anybody ever needs help with an appeal from a poverty decision, we've got templates. I would love to talk to you about that.
And just a quick follow-up, and that would be a decision that the municipal court judge would make, not necessarily something you might see in a stipulation, an order. Is that correct?
Well, sometimes like on a deferred prosecution agreement, you get somebody who says, we'll have them do 15 hours of community service and not get new tickets during 6 months. And that's kind of a condition of the DPA. You certainly could agree with the prosecutor that community service would be appropriate, but I do think at the end of the day, it has to be assessed by the judge or approved by the judge. And, oftentimes we get prosecutors who are okay with community service, or frankly don't care one way or the other what happens with the forfeiture amount. But I think it's generally the judges that we have issues with, because I think it is a judge's decision at the end of the day. Is that your experience, Kori?
Yeah, I've only had, I think, historically one prosecutor who wanted a say on a forfeiture. I generally think it's something that the courts are dealing with, particularly if I'm getting pushback. I would say now in this day of COVID, where community service is not really practical anyway, that this is also a very good time to just be asking them to stay it. Pile on, good reasons, in terms of, your client's inability to pay, but also, don't be afraid to advocate using the circumstances of the times. There is no community service. It's not safe. So let's just let this young person move on and get on with his or her life.
Great. Are there any other questions? Feel free to throw them in the chat or the Q&A. Just hang out for another minute or so. But absolutely, and I know we talked a little bit about this, I think in part 2, but are there any particular notes on this in post-judgment matters related to youth who might get a ticket related to protests versus adults?
Just that they're likely to look at driver's license suspension. It's a huge problem for young people, especially trying to start to get their first jobs and things like that. It is a little bit trickier because it's appropriately harder to get information with juvenile cases. And so it can be a little tricky to get those court records and figure out what's going on. So that can be tough.
And if you are trying to get juvenile records from, at the very least, City of Milwaukee, there is a form. It's not easy. There's a form that you have to have signed by your client or their guardian. I feel like every time I go and try to do it, I'm given different instructions, but it's not as simple as going and requesting the forms. You should know that. So plan for a little bit of extra time. They won't give them to you over the phone or by fax. They won't accept it by phone or by fax. Maybe now with COVID, I haven't tried. But I would be prepared to do a little extra legwork in getting those juvenile records. I've had people be fairly sympathetic to juveniles. I would imagine in a protest case I would hope there would be, empathy there, but who knows at this point.
And one thing that I failed to mention at all that Kori talked about a little bit is that the municipal statutes were updated recently, and one of the massive benefits to the change was that poverty hearings and hearings on motion to reopen, so all appealable decisions, the underlying hearing has to be recorded now. This is a huge benefit, and if you're having poverty hearings and it's not going well, you should definitely try to make sure that gets recorded, because it is really hard to appeal a decision where people are disagreeing about what occurred. It's much easier when you've got a recording, and we have found that the municipal judges are very resistant to recording these hearings, and I think the reason is obvious, that they are not following the law in the vast majority of them. And so to the extent that we can push the agenda that these hearings need to be recorded, I think that is a great benefit to our clients.
Yeah, absolutely. Great point. Well, if there are no other questions, I will just thank you both. Thank you so much, Susan and Kori, for this really informative training. Again, I will upload all of the videos and our PowerPoints in case you missed any of the other trainings that we had in part 1 and part 2. And feel free to reach out as well if you have any additional questions after you look through the materials. If you have some additional thoughts or comments, please feel free to reach out, and I'd be happy to answer them as best as I can. Otherwise, thank you so much, everyone, and have a great afternoon.
Thanks, Emma.